Morning, Jellicali. Sorry, I'm still getting the last of the morning report out. I'm going to try to do both at once. Morning, Easy K. So the court never had jurisdiction here. The court never had jurisdiction here, but they waited 5 years to file a motion to say that. So that's what the case is about. The court never had jurisdiction in the first place, never had personal jurisdiction because the dude lived in New York. This was a Tennessee court. But they waited like 5 years to say, you don't have jurisdiction. And they're like, you're right, we never had jurisdiction, but it's too late for you to file that motion. So that's the question. Do the rules of void judgments overrule the procedural rule of how long you're allowed to file this stuff? So there's our question. If it was always void, does it not become not void? Well, no. But you still have to be able to assert that it was, and for how long can you do that? Can you guys hear okay? Is everything? It doesn't look like the audio is coming through from the court. Can you guys hear the court? You should be able to hear them, so what's going on? Shoot. Let me find out. Sorry, guys.
Scenario in which a Rule 60D1 motion is filed is when somebody has run out of time to with Coney Island's position, then that would be the end of the case because, well,
you
I guess
really want to give up the D1 argument?
I guess it would depend on exactly what the court's holding is. So if...
How would you have us write it to preserve that option for you?
I guess I would request
If you want to preserve it.
Roney, is it back?
I would always want to preserve it, but I would write it respectfully. I think the court should write it as saying that the reasonable time limitation in Rule 60b-4, the reasonable time limitation in 60c1 does apply to 60b-4 motions, but there is also a time, there is otherwise no time limit under Rule 60d-1.
If you had this independent collateral action, whether under 60d1 or imagine a world without 60b, and you can just bring an independent collateral attack on the judgment, would the defense of latches apply, or would your reasoning there be that, no, there just can never be any limitation, no statute of limitation, no latches defense from the other side if a judgment is void ab initio?
I'll be over in a second.
I would say, Justice Barrett, that yes, that there is no latches argument to be made in connection with a void judgment, in the void in the pure sense of the term.
And what do you do with the history? I'm sorry. What do you do with the history that some state courts for decades have applied latches to just this situation? Doesn't that defeat your common law understanding?
I believe, Your Honor, that if we were to, or if the court were to rule that latches cannot apply to a void judgment, then that would.
Yeah, you're asking us to rule that way
Right.
because you say there's a common law. But if there isn't a common law, because there were latches applied by some courts, not all of them, but some, doesn't that defeat your argument?
I would say, Your Honor, that it would not defeat the argument, because if the court were to find that a void judgment cannot be given effect for due process
You're going
reasons.
around in a circle. We can only find that if there really is a common law rule and Rule 60B doesn't override it, because common law rules can be overwritten by 60B.
Correct. And so.
And so if we look at what the advisory committee said when it was creating 60B, was that it wanted to
Sorry, I've been quiet, guys. I'm trying to wrap up the morning report at the same time, but I didn't want to wait any longer to log in. Morning, everybody. Oh, is it? Did it go out again? Does this keep happening? Give me one sec. Sorry.